historic opportunity. It's a chance for Democrats and Republicans and our independent to come together and solve one of the more serious problems facing California. A workers' compensation system that is increasingly more costly for employers, provides inadequate benefits for permanently injured workers, and subjects both employers and employees to unreasonable delays in resolving medical and legal disputes in the system. A good thing happened. Labor and management came together and shared their ideas on how to improve the system. They recommended ways to improve it for themselves and for their workers. Over the past several days, also, more and more organizations have signed on to support, from the Building Trades Council and the Teamsters, to the California Medical Association, to the Chambers of Commerce and Grocers Association. They are all in support now. The growing number of supporters on both the labor and employer side is a testament to the strength of the bill. The bill is complex. It does reflect trade-offs and compromises. It was not written all by one side, but rather it has been a process of give and take. Well, what does the bill do? In a broad sense, it provides consistency and certainty in a system, and it reduces frictional costs in order to finance long-term permanent disability benefit increases for injured workers. Specifically on the benefit side, there are two key provisions. There's a permanent disability benefit increase estimated to be more than $700 million annually, again, $700 million annually, to be spread across all classes of employees so that no class loses as compared to current law. This translates into a 30% increase in permanent disability benefits for workers. There's also a new $120 million catastrophic injury program that is designed to enhance the benefits for that small group of injured employees whose permanent disability ratings are disproportionately low as compared to their earning loss due to that injury. On the medical treatment side, there's also good news. There's a mutual desire that disputes about treatment be resolved quickly and by medical experts. Today, lawyers and judges make those medical decisions, and the process is so cumbersome that it can take up to a year or more. And during that process, the injured worker is not receiving the medical treatment they deserve. This labor management agreement instead adopts an independent medical review process patterned on the system used successfully in health insurance for 10 years. Under this process, that is evidence-based and made by doctors, decisions are made in 30 days. The question sometimes is, what if the medical experts get it wrong? Well, the answer is this: doctors will get it wrong far less often than lawyers and judges. The best ways to characterize the many other provisions in the bill is that it's an all-out assault on waste, fraud, and abuse that we all keep looking for here in state government. Over $1 billion in savings is being made by agencies in the system. Price gouging eliminated, and conflicts of interest banned. This bill will also avert the crisis of the pending 18% workers' comp rate increase for employers large and small. And those 18% rate increases can start as early as this October and for sure January, so we need to avert that. This is also important as we're seeing the economy recover and the economy grow, that we want to bend those cost curves down, and rather than having more employer money go towards these inefficiencies, instead we want to see those resources spent towards hiring new workers, increasing wages and benefits. Members, this is a good bill, and it deserves our bipartisan support. I ask for your aye vote.
Mr. Hueso.
Thank you, Madam Chair. When you introduce a bill in the final week and have the first committee hearing on the final day, I can only suspect what this bill is really about. A 170-page bill that purports to create all these wonderful things that we all want, yet introduced in the final day. I don't know how anybody could support this in this fashion. I want to get to meaningful workers' comp reform. I think we all should work on that. But in the manner that this bill is being introduced, it's highly suspect. There really hasn't been a chance for meaningful investigations, even for people in the public to come in here and weigh the benefits of this bill. if we should, I mean, we're doing an enormous amount of work in this final week, and this is one of those last-minute maneuvers that has me highly suspect of what's in this bill. I can't vote for something that I can't explain, and I can't explain if this is going to be a good bill or a bad bill. I have no idea. A 170-page document, ladies and gentlemen, completely changing a system that's highly complex. I heard comments today about the pension and how, you know, this was a last-minute backroom deal on the pension, something that we've been discussing for 9 months. Somehow happened too fast. Yet, not a single discussion this year, not a single debate either through the media or through the community process or through the bill introduction process. And now we have a 170-page bill on our desk for approval. What's the hurry that we cannot give people in our community the opportunity to weigh in? What's the scrutinize this bill? What's the hurry that you have to bypass every single process? How does this bill get around appropriations? How do we know it doesn't have a fiscal impact? Why did my bills go through appropriations and then they didn't even go up for a vote, whether up and down? They didn't even give me a reason why they couldn't get these bills. No committee process on the last day with very little participation from our own community. I hope we don't support this today, because it's going to send the wrong message to our community. They're already asking questions about backroom deals. Let's conduct ourselves with more honor, and let's conduct ourselves with more, dignity. Let's involve our community in our decisions. Let's get them to share, this process. 170-page document for them to expend resources, and even reading this or understanding this in one day is just, it's just not right. And I would respectfully request, I've heard arguments today from people on both sides that things are moving too fast. If you think we should be passing a bill in one day, I want to see who believes that today, and really hope that you can remain consistent in your comments and in your votes. I respectfully request a no vote.
Miss Atkins.
Thank you, Madam Speaker. To the merits of this bill, a great deal of debate over this reform has centered around low-wage workers, as you've already heard. The good news is that, as we've mentioned, every category of worker gets an increase. Worker representatives entered negotiations guided by the principle that all injured workers deserve a benefit increase. This principle is reflected in the bill before you today. Both sides agreed that harsh cuts of 2004 went too far. Workers have been demanding relief ever since, and SB 863 offers a powerful solution. Under this bill, every worker gets a raise, young and old, high wage, low wage, severely disabled, and slightly injured. All were to be made whole, and all see substantial benefit from this bill. For those at the low end of the wage scale, those with especially immediate need for medical treatment and disability benefits, the combination of faster treatment and larger awards can make the difference between returning to the workforce and are falling through the cracks. We owe these workers more than the broken system we've given them. Some opponents have said that somehow this bill changes the process by which workers qualify for benefits. This just simply isn't true. Every injured worker who qualifies now still will in the future, but the only difference will be much higher benefits, fewer delays, and a more equitable, sustainable system for everyone. I strongly urge an aye vote.
Dr. Halderman.
Thank you, Madam Speaker. I'm extremely troubled, and I will ask a rhetorical question of the universe, given the previous bill and also the statements of my fine yellow-tied colleague with whom I agree. Has the zombie apocalypse started? What's going on here? This is the weirdest thing I've ever seen. First of all, to this bill. And I think my colleague was too, and I don't get that. To clarify, we talked a lot in the introduction about the physicians who are in favor of this, the California Medical Association, that the CMA was oppose unless amended, and the amendments required an additional consultation fee, which is nice, thank you. It doesn't exist in Medicare, so I'm not quite sure what it's doing here. There's one group of doctors that was omitted when the introduction was given about who agrees with this. That would be the group of doctors that actually care for workers' comp patients. Physical medicine and rehabilitation, orthopedics, chiropractics, anesthesiology, psychiatry, psychologists, industrial medicine physicians, rehabilitation professionals. We know what they'll do. We've seen it before. Just look at Medi-Cal. They'll stop taking care of these workers' comp patients, and we can all feel good that we did something really wonderful for people who are suffering and were injured. But we've done nothing for them except to decrease their access to health care. There's another part of this bill that's very problematic, and it's what it does to the place where workers' comp patients are most often operated on, ambulatory surgery centers. Why are they operated on there? Reason number one, it's less expensive. The ambulatory surgery centers are more efficient, they turn over rooms faster, and their survival is based on their ability to keep ahead. This bill reverses that. They would have to agree to accept Medi-Cal rates. That is not tenable. We go to ambulatory surgery centers ourselves because we like them. We like how we're treated, we like our experience, we like not being exposed to methicillin-resistant Staph aureus when we go to these places because they're outpatient. That is the predominant class of workers' comp patients we're talking about. This is a harmful bill to the people we're purporting to help. I would strongly urge a no vote on their behalf.
Mr. Calderon.
Yes, Madam Speaker, members, I rise in opposition to this measure. There are two ways that you can go for worker compensation. You can go towards that side where injured workers are allowed to go before a compensation court and prove their injuries, or you can go the other way where there's a total formulaic approach and you plug the particular individual into that formula. There has been a lot of criticism by the employer industry that we've gotten too far to the former, so this moves us back to the latter. But people are not, individuals are not something that you can plug into a formula. And my biggest concern with this is that there's a lot of winners in this. But in order for there to be winners, there has to be losers because this bill purports to raise about $1 billion. The losers here are injured workers who cannot go back to work. If they cannot go back to work, this formula now takes their ability away to prove lost wages. And so consequently, although rates will go up for everyone else, for an injured worker who cannot go back to work, the rate of compensation will go down. And that's my biggest concern with the bill. Now, I'm grateful because in response to comments that I made in that regard and others, $120 million was put into the bill to compensate those workers. But here's the language. $120 million will be available for the purpose of making supplemental payments to workers whose permanent disability benefits are disproportionately low in comparison to their earnings loss. What does that mean? Disproportionately low in comparison to their earnings loss. So we're told then, well, you know, the Department of Industrial Relations will do regulations, and they will identify what that means. Well, in 899, when we had some reform, the Medi-Cal schedules were adopted as fee schedules, and nearly every state that has adopted Medi-Cal fee schedules to determine compensation worker compensation rates, they adopt this RBRVS. It's the resource-based relative value system. California never adopted that, although that was anticipated as part of the 899 reform. So now we're going to sit here and we got to say, okay, what are the regulations as it relates to this $120 million? We don't know. Moreover, a third of us will be gone by the time out of this legislature, by the time that those regulations are adopted, a year or maybe 2 years later. So my main concern is not that we increase benefits for everybody else. My main concern is that for the people who can least afford to have their benefits lowered, we take money away from them. I just don't think that's the right approach. I think a little more time would have produced a better product. And so I reluctantly ask for no vote.
Mr. Hagman.
Thank you, Madam Speaker. I appreciate the opportunity to speak on this matter. I rise to support this bill. And to my friend from San Diego's, welcome to our world where the last minute we get to see the language and have to vote on things. That seems like we do more of that, especially the last 2 weeks of session. But I can say as Vice Chair of Insurance, working with the author who then was chair, is many of these issues were taken up. Back in 2004, when Pochigian did the major work comp reform to get California's worker comp within line in competition with other states, so we can actually employ more people here, what a concept. A lot of reforms happened. In that, most people on both sides of the aisle believe that a certain class of workers who got injured, particularly the permanently disabled, got the wrong end of the deal. And over the years, through lots of court cases, more and more of the money that used to be spent on the workers is now being spent on litigation in courts. In fact, the studies we saw over the last year, up to 35% of all the pooled money was actually being spent on litigation in courts on worker comp claims. The employers, the unions, and the employers, the businesses, actually got together over the last 9 months. And again, we're talking some individual bills in committee this whole time, and came up with a deal where they both lost and they both won. Neither one got everything they wanted. But what they did do is take that 30% that they're losing and try to streamline the process so the injured worker can be treated quicker, faster, and better, and put it back in the system. And actually, those who got permanent disabled qualifications got a higher benefit. There's certain regulations that are not done yet. I'm sure there's going to be follow-up legislation on this, but this is actually an instance where the process worked, where the people who are involved with this both support this bill. The people who live off this chaos of workers' comp in California, primarily those who represent someone who doesn't feel they got the right benefits or wants to go get some specialty stuff here and there, those are the people who are opposed to this bill. Again, I'm sure that the insurance chair and I are going to have to do some follow-up stuff, and there's some things I have concerns with as well, but this is a big step forward that hopefully we keep the insurance premiums to employers down to a stable incline and not raise it up like they're predicting right now, 18% this in a couple months, and to have both labor and the employees, which this is a contract. Workers' comp is a contract between the employer and the employee. The employee saying, I'm not going to sue you in court, but you got to take care of me if I get hurt. That's what we established a long time ago here. Both of these parties overwhelmingly support this bill, and I urge your aye vote.
Mr. Nastandi.
Thank you, Madam Speaker. The new amendments to this bill ensure that workers in the most hazardous industries, like construction, will have a chance to obtain a more fair benefit. The system was created to ensure workers are not left out in the cold. If we want to protect our employees without driving our economy into the ground, these reforms are necessary. The current system is wrapped up in red tape, it's too expensive, and it's hurting California employers. The bill is needed now. Employers need it. Workers need it. California needs it. I urge and I vote.
Mr. Dickinson.
Thank you, Madam Speaker. I completely appreciate the very hard work that so many have put into this particular subject over the last week or somewhat more. I have to say that I think this is one case in which a more deliberative process would have ultimately had the potential of yielding a better final product. Even in the last day, we've seen an amendment which I think improves this legislation. It's been referred to and discussed already in earlier comments, but I think it signifies the fact that had there been a bit more time taken with this legislation, we might have come to a better place in the final analysis than we have before us today. There is, however, a great deal in this legislation that commends it as well. And so while I have significant reservations along the lines of those described by Mr. Calderon and others, in the final analysis I have come to the conclusion that the meritorious elements that we have in this legislation overcome those reservations for today's purposes. But I would also simply leave with you the thought that by proceeding in the way we have and arriving where we are today with this legislation, we also are creating the very great potential that within a short number of years we will be back addressing what will then in the future be seen as the shortcomings unaddressed today by not taking a little bit more time. So we make a step forward hopefully today, but we also, by not doing as much as perhaps we could have, leave an open question for tomorrow that legislatures of the future may still have to address to make sure that injured workers are treated fairly and appropriately.
Mr. Bell.
Madam Speaker and members, I'd like to make an inquiry regarding this bill. I would like to know if this bill has contained in it, fees and surcharges, and whether or not those fees and surcharges require a 2/3 vote of this body to approve them.
Ms. Grove? Huh? Oh, without objection?
And there was an inquiry. Would like to answer it. Most all this is paid by the existing workers' comp system, so it's paid by employers through insurance premiums. You may be asking about the new $120 million program, and that's going to be funded through an existing assessment that employers also pay into. So there are no new fees, an existing assessment system. So it is not a 2/3 vote bill.
Okay, so has the legal determination been made that we have a bill that it can be approved with a majority vote?
Correct. Yeah, legal counsel looked at this, and it's a majority vote bill.
Ms. Grove.
Thank you, Madam Speaker. Over the last 2 years, since it's our last day in session, none of you have any doubt in your mind how I feel about labor unions. None of you. I mean, all of you have there's no doubt in your mind how I feel. There's a saying in politics, and I've heard it a lot, and I didn't understand it until this bill came together, that politics makes strange bedfellows. So when you think about it, this bill is a perfect example of that, because labor came together to benefit the injured worker, and the business group came together to benefit reduced in premiums. The workers' comp system was established in 1920, and that system was created a no-fault system, and there were two stakeholders. There was the employee, who deserved the highest amount of benefits, and the employer, who deserved a compensatable rate that was adequate. Over the years, it deteriorated and different people got involved, and it created a middle person, or people in the middle, that continually got more out of the system, to where in California we paid the highest rates for premiums as employers, the highest rates in the nation, yet our employees received the lowest benefits that were available in the nation. So the middle ground individuals had gotten more and more and more of the pie, and employers continued to pay more and the employees continued to get less. This bill coming together with two sides who I think are truly the original stakeholders, labor getting for the employees which they truly deserve, a huge increase in permanent disability benefits that was removed by the previous workers' comp legislation, but yet the cost to employers being offset by other costs that it didn't cost the employers any more money for the premiums. Many business groups have come on, many labor groups have come on, people from both sides of arguments that you never thought in a million years would agree on anything have come together and represented the individuals that they represent, and this bill has been worked out. I learned a lot of other things during this process. I've ran into very few people that vote a pure heart vote. I see people that go, you know, maybe this, and I can vote for it. It's just interesting how people can't vote for what is truly a pure thing. There's no hidden things. If I understand anything, I understand business and workers' comp. And this bill put together by labor and the employer and the business group, by the two true stakeholders that make a difference, increase benefits to the injured workers that is severely an increase. It's really a great benefit to injured workers, but it doesn't increase the cost on the employers. So the two stakeholders that really matter and make a difference, they really have worked together across the aisle to make sure that this goes into effect. So I would just urge a yes vote.
Mr. Nielsen.
Madam Speaker, ladies and gentlemen of the Assembly, this is worthy of a yes vote. More so than many of the previous reforms, which resulted in very substantial benefit increases, but very little in terms of reforms. As a matter of fact, some of the previous ones made the system far worse, more litigious, rather than not. This one has not accomplished it, and it has evolved at the last minute, which something is of distaste to me, but it has evolved successfully nonetheless. And even till just a little bit ago, I was ambivalent of how I would vote on this, but walking back from our break down the hallway, looking at the smiling faces of some of the folks in the business community, almost a cautious and hopeful relief look from the heavy burdens of these many weeks that they've been working on it, and of course the last minute frenzy. That gave me some comfort that they truly believe there's something good for them here. I believe that from looking at some of the labor folks that I've talked to as well, that they believe this is an able compromise. At the least, I would argue it is not, as many in the past, make a system that was bad even worse. This is a step forward, and it is worthy of an aye vote.
Ms. Olson.
Thank you, Madam Speaker and members. I, too, urge an aye vote on SB 863. As a member of the Insurance Committee, I've spent a lot of time over the last week looking at the pros and cons, the ins and outs of this particular proposal, and I really have come to view it as a win-win. Employees are going to get better benefits than they've had for the last 10 years. Employers, including our smallest businesses, will be able to avoid what could be an 18 to 20% increase that's coming just around the corner. And not only that, but State Fund has announced that it could actually lower costs by 5 to 7% immediately. This is a win-win. Is it perfect? No. I don't know if I've ever seen a proposal that's perfect, other than one that maybe I introduced on the first day of session. But it's a win. I'm not sure I've ever seen on any other piece of legislation such a lengthy support list of groups that are usually on polar opposite sides, but they've come together because they see that by working together, we can help businesses, we can help employees, and as such, we can help the state of California's economy and avoid what could be disastrous in terms of the increases that are pending just around the corner. So I encourage all of us to come together in a bipartisan manner to support this proposal, to stand up for injured workers, to stand up for small businesses. Please vote yes on SB 863.
Mr. Smythe.
Thank you, Madam Speaker. Members, I don't want to belabor the debate, but it is the points that have been made about sides, opposing sides coming together Certainly, again, we can always find things that are wrong and aren't perfect, but when you see, as mentioned, the list of supporters on both sides stepping up, I think it's a bill worth supporting. If changes have to be made and tweaks and fixes, there certainly is that opportunity, whether it be through a special session or coming back in January. And in talking and seeing, hearing from the business community, it reminds me to kind of paraphrase a quote from a great 21st century poet, Sean Carter. The business community may have 99 problems, but this bill ain't one. I ask for an aye vote.
Ms. Skinner.
Thank you, members, and Madam Chair. I struggled with this, and I am a member of the Insurance Committee, so I've had 2 committee hearings on the subject. And as I came down on I come to a yes on a couple of key points. Some of them have mentioned, so I'm not going to repeat those. But one of them was the independent medical review. I had a concern that with some of the changes that, in my own view, there's rarely to ever a one-size-fits-all that works for people and in any kind of situation. And so I was concerned that there were some kinds of injuries or some kind of workers that would be affected that wouldn't just fit in categories. But I felt that the independent medical review, once we heard the testimony and once I was able to ask some questions and meet with some people, was going to help ensure that those workers who had unique situations, their concerns would be addressed. Now, the other place that I came down in this is that in the early 2000s, when I myself had about 30 employees, and health costs, health premiums were going way up, and workers' comp was going way up, I was facing a situation where I maybe would have needed to lay people off. Thus, I would have had to put people out of work. And I know that since the recession, business owners have only experienced that worse. And it is my hope that with the Supreme Court's upholding of our federal new health care laws, that our health care costs will go down. And with this action, our workers' comp costs will go down. And that employers will not only retain the employees they have now, but they will start to hire again, which is so needed. I ask for an aye vote.
Mr. Logue.
Thank you, Madam Speaker. I also rise in support. This is, I think this is a tremendous story for our institution to bring both parties together, and business and labor. This sends the right message to the people of California and the right message to the people of America that we can move forward. This will help the business community, and I believe this is a turn for the better. I rise in support of this bill. Thank you.
Seeing no further questions or debate, Mr. Solorio, you may close.
Thank you, Madam Speaker and members. Just a few things. First, process-wise, I would tell you that this bill is actually years in the making. We have had a joint hearing earlier in the year on this. All these ideas were raised in that hearing. This bill just crystallizes many of the solutions. There was a roadshow by the administration where there were hearings up and down the state with the administration talking to employers and workers and folks in the labor community about it. We also have had bills in this area over the past couple of years. And on this bill itself, we've actually had 2 bill hearings in Insurance Committee about this, so it's definitely, it has had its time in the sun. Have there been tweaks in the past couple of days? Yes, but that's only made this bill a stronger bill. With respect to the medical groups, I would like to clarify that the Orthopedic Association does not have an opposed position, and that in addition to the Medical Association supporting the bill, we also have 2 other medical groups supporting the bill. Those are the Occupational Medicine Physicians and the Physical Therapy Association, so those are 2 additional good groups. Finally, there's been some discussion about those special workers that maybe deserve more than just the regular 30% raise everybody would get. And there would tell you that the special program of $120 million for the special injury program is more than the $80 million that it seeks to offset. So it is an improvement. I do also want to thank and compliment the new chair of the Insurance Committee, Assemblymember Henry Perea, for conducting 2 very good hearings on this. And in today's hearing, the discussion from him and some of the other committee members were maybe on having interim hearings on how the administration will roll out this program, what they are thinking about with respect to the regulations of this new $120 million program. I think that's a fine suggestion, and do think, though, this is a great bill for California. It's a great bill for businesses at large and small. It's great for our employees, and it's also another way that we can get our California economy back on track. I recommend a strong aye vote. Thank you.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 66, noes 4. Measure passes.